Alex here with part 166 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my access parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the judge's order expunging writ of execution. I am 99% sure that this is a copy-paste of the order denying motion for supplementary proceeding. It certainly is going to be based on the same points. One thing that I do recall being very strange about this order is that this order did not include an award of attorney fees, even though it was based on identical assertions and arguments. Why would the judge award attorney fees with the supplementary proceeding but not the writ of execution? The only thing that makes any sense is meta rulings. It's as if the judge wanted to find a way to split the baby down the middle and give him a little bit of something that he wanted and give me a little bit of something that I wanted. It doesn't say that outright, and it really can't, because that would be an abuse of the court's discretion. That's not really a judicious thing to do. I mean, any random neighbor on the street can do that. You don't need to go to law school to decide, hey, these two people don't agree, give this guy half, give this guy half. But for whatever reason, in family court, this is extraordinarily common, that the judge will violate the law in favor of an attorney because they feel bad for that attorney not getting anything that they asked for. If I'm mystified by this. Everything that supported the award of attorney fees in the first situation, which was a supplementary proceeding situation, awarded the award of attorney fees in the writ of execution. And the judge doesn't mention this in the order. She doesn't say, hey, I know I awarded fees in that last order, but I'm not going to award fees in this order for this reason. She doesn't explain why she did this, leaving us to only guess that she wanted to let him have fees on one but not the other. I mentioned this on appeal. I was myself quite mystified by that, and the appellate court doesn't talk about it. They just overturned the decision out of hand. So you guys yourselves take a look at this order compared to the other order. There's nothing different about the order. She says the same things about me here that she said there, and yet for reasons that have not been explained, she denies the cost or the fees award in this one, but not in the other one. So if you guys haven't seen the video Meta Rulings, it's really important that you go and watch that video, and you'll see why. I published that video. It just seems so... It's tough for me to do these videos and keep a straight face, because I know that for myself going into the legal system for the first time, I just thought it was a place where extraordinary people took the bench, because, you have to be kind of extraordinary to judge others, and there really isn't anything like that. Over and over again, we see that in this case, and this is just another situation where we just see the same thing. Now, I think a lot of people are going to be asking me, hey, Alex, shouldn't you be happy that you didn't, get sanctioned on both cases? Yeah, obviously. It's not going to matter in the end, because the other decision is going to be overturned. But obviously, I would rather not be sanctioned 2 times, if I can only be sanctioned once. But the thing that I have to say about that is, this isn't really a channel that's here to say, hey, I'm glad that I got away with this. This isn't really the position that I took, because then I would have just walked away with it and not filed an appeal. I know that's nice that she did that for me, from her eyes, from her perspective, but from my perspective, she shouldn't have sanctioned me in either case, because the law said so. And it would have been a lot more logical for her to impose sanctions in both cases, or neither case, than for her to do what she did here, which was, there's nothing logical about it at all. It's just trying to give one guy, something that he wanted, and trying to give me something that I want. Again, guys, please watch the video Meta Rulings, because you really need to be prepared for this kind of, I hate to say it, incompetence when it comes to dealing with the family court system. Anyway, with all that being said, let's go ahead and take a look at this judge's order. have the order expunging writ of execution. As I mentioned earlier, guys, I am anticipating that most of this order is a copy-paste of the previous order denying motion for supplementary proceeding. I will be skipping over those portions that are copied. And as with my previous videos in the My Docket series, you can always go down in the description below, click on the link, download the document for yourself, and if there's something in there that you think I missed or that you think I should have addressed, you can always go ahead and put that, post a comment down in the description or send me an email. Again, if you want to go through the analysis on these arguments, you're just going to have to go back 2 videos and watch the my, I guess you could say, commentary on the order denying motion for supplementary proceedings. So, so far I see the findings of fact, just like I mentioned last time. This is very strange because we didn't have an evidentiary hearing. This is just copy paste. Everything here is the same. Again, everything here is the same. Conclusions of law. The writ of execution is expunged. The court established a payment schedule, which is subject to enforcement if necessary. And the request for attorney fees is denied. There's no... Why? Why was the writ of execution appropriate, but the motion for supplementary proceeding not appropriate? What's the difference? Again, I'm mystified, guys. Take a look at the other order. Everything... I don't know what to tell you guys. For no reason, she denies this attorney fee request and grants the other one. Anyway, let's go ahead and go into the certificate of electronic service indicating this document was mailed to both. Like, this is seriously court. Like, this is like random. It's like they're making random decisions. This is so strange. Anyway, this document was mailed to my ex's attorney and my attorney. That's it for that. Verified memorandum of attorney fees and costs. Okay, so I didn't know that they're supposed to do these in the same document. Costs should be in a memorandum of costs. That's true. But attorney fees, I think that's supposed to be under a Brunzel affidavit. I guess he just kind of blobbed them together. So what do we have here? I don't see any costs. I just see attorney fees. Yeah, because you can see that these are all hours. So all of these are all attorney fees. Okay, here's some costs. But he didn't separate the costs out. Oh, no, he did. Here we go. $35.64 in costs and $1,680 in attorney fees, which comes to a total of $1,715.64. Okay, so I think if he would have separated these out, he might have gotten away with these costs, $35.64, but he lumped them together into one document and the entire amount gets vacated. Okay, well, and anyway, this is a memorandum. It goes through the billing of all of the fees that he wanted to charge my ex for. Here's the verification. The verification is just sworn under penalty of perjury, but this is not consistent with the Brunzel affidavit. So maybe he goes into that later. Certificate of service. Here is the certificate of service indicating this document was mailed to my attorney. Here is the affidavit of Raymond Oster. Okay, so this affidavit here might be consistent with Brunzel. So let's take a look. Exhibit 1. And here's the affidavit of her attorney. He is the attorney on the case on or around December 12th. He goes into the motion that I filed. Okay, so this is a Brunzel. Okay, yeah, this is the... Wait, why is it Miller v. Wilfong? That doesn't sound right. I haven't looked at this case, guys, but this doesn't sound right to me. This might be what they use in divorce cases, not in child custody cases. That might be why he confused the judge. That might be why. Hey, if anyone wants to take a look at Miller v. Wilfong and post something in the comments below, that's cool. I'm not going to bother doing it because as far as I know, this case is not applicable to the instant case. Unless that's the case that explains you need to look into the financial abilities of the parties before awarding attorney fees. That might be that case. Again, it doesn't, I'm not going to spend any time on it because it doesn't help him. He's going to get overturned on appeal anyway. And this looks like this satisfies the requirements of Brunzel. Let's keep looking. Yeah, okay, so this section here, section 4, where he talks about how the rate is charged based on the standards of the family law section, and then he goes into this law firm that he works for, which is Valoria, Oliphant, Fallendorf, and Oster. He talks about his experience, the hourly rate, $400 an hour. I'm going to keep charging my ex $250 in the aftermath phase just because it's just what I've been doing the whole time, guys. I know she pays more, but in actuality, I'm not really trying to get that as accurate as possible. I'm kind of trying to, I mean, seriously, if I wanted to do that, the aftermath section would be so granular, and that's just not what I'm going for. Anyway, he goes into why he's qualified to charge this amount of attorney fees, and this is definitely consistent with the requirements under Brunzel. So whether he means to or not, he's satisfying the Brunzel requirements. The Miller v. Wilfong thing is something else. I don't know what that is. All of this here is going to his education and his expertise and all of that. This is required, guys, under Nevada precedent. They have to file this or they can't recover attorney fees. Okay, I think that's everything. Next document is the declaration of service. This is the sheriff declaring that he served the writ of execution upon my ex's job. Of course, it's not going to matter because the judge is going to quash it anyway. Actually, she already did. That was the first document. And then this is the writ of execution that was filed. And again, guys, I know we've already talked about this, but this was entered by the clerk of the court, not by me, not by my attorney. It's entered by the clerk of the court. Next document is the non-opposition. Now, this is something that I think a lot of my viewers will be curious about. Why did you file a non-opposition to your ex's verified memorandum of attorney fees and costs? I thought you opposed the costs. The reason why is because I'm not objecting to the amount of the award. What he stated, his expenses were, it seemed reasonable to me. So I didn't have any objection to the amount of the award. I had an objection to the award in the first place. And the other thing is I was very cognizant about the fact that I had a friend who was helping me for free. She's an attorney. She's helping me for free. And I'm not going to abuse her by having her file oppositions and spend all this time on this case for free when there is really no basis for an opposition. He filed his Brunzel affidavit. It stated clearly why he asked for that amount. And I feel that the amount he's asking for is consistent with the amount of work that was done. If I feel that way, I'm not going to oppose that particular thing. I'm not going to make them do all kinds of extra work. I've already talked about this. This is not a case where I fight fire with fire. In fact, I have a video on the topic, fighting fire with fire, and I urge my viewers not to do that. So I filed a non-opposition to the verified memorandum of attorney fees and costs, and I'm going to allow him to go ahead and secure that $1,600 whatever dollar order, and then I'm going to file an appeal and get it reversed anyway. So this does not impact my appeal. I'm still allowed to file an appeal as to the award. Now, of course, I'm not allowed to file an appeal as to the amount. I would have waived that because of this non-opposition. But this does not affect my ability to challenge the award in the first place, and I will challenge that award, and I will win on that basis. If you guys want to know more about non-oppositions, please watch my video on the topic, non-oppositions. Certificate of Rule 5 service indicating that this non-opposition was sent to my ex's attorney. So for all these people, not my viewers, not these people, for her attorney and her friends and family and anyone else who supports her case, trying to say that I'm just, and even the judges trying to say that I am a vexatious litigant and I'm just trying to file papers to cost her more money. This is yet another example on a mountain of other examples of me doing exactly not that. Request for submission. Here is a request for submission filed by my attorney submitting the verified memorandum of attorney fees and costs to the court. This keeps her attorney from having to do anything. Because I filed a non-opposition, she's not allowed to file a reply. That's one of the other wonderful things about a non-opposition, is it blocks your opponent from filing a reply. There's nothing to reply to if you don't oppose, the thing that, the issue that's before the court. Certificate of Rule 5 service indicating that this document was mailed to her attorney. And then her attorney files a request for submission anyway. So this is a waste of money for my ex. He's charging her attorney fees to submit something to the court that we've already submitted to the court. Why is he doing that? This guy's doing one strange thing after the next. And then we have an affirmation under the law, and then we have the certificate of service indicating that this document was mailed to my attorney. Seriously, the only reason that he could have possibly used to file this is to charge her more money. There's no reason to file it. We've already filed it. Okay, so I filed my ex's attorney filed the motion to expunge, and the judge has granted that motion, expunging the writ of execution and thus preventing me from executing on my ex's assets. Going into the aftermath, I have filed 1, 2, 3, it looks like 3 documents. No, wait. My ex's attorney, okay, hold on a second, guys. I filed 2 documents, only 2 documents. Those are free filings, so I incurred $0 in costs. My ex's attorney filed 1, 2, 3 documents, but those are also free filings, so she incurred $0 in costs. I had an attorney, but she was representing me for free, so I incurred $0 in attorney fees. My ex's attorney would have, let's see, for the verified memorandum, that's going to take him some time to put together. I would say probably 3/4 of an hour, but when you go ahead and lump in all of the other documents, the request for submission, the fact that you have to review our filings and the court's order, I think it's reasonable to say 1 hour of attorney fees went into this for my ex. At the rate of $250 an hour, that's going to come to $250 in attorney fees for my ex. As in my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.